for motion. Item number 1.
It is a foot 38 application, and my lord, you have already perused the CV and granted bail from 1-2%. Of course, for 39 your lordship granted. And your lordship,
for your this
My-
applicant, perhaps I have not perused the case again.
my case, you not produced, my lord, that's why. But your lordship has produced the case diary and found that more than 100 bags have already recovered from some person. And I was not the driver even, my lord. The driver also, the actual driver, his name is there, my lord. But police is asking, always visiting my house, you have to come to my house, police station, my lord.
Mr. Locker, perhaps we have called for the case diary.
Lordship.
When?
I cannot recall. I cannot remember.
Kobe?
City number.
PS case number 30. I have go to Azara PS case number 85.
24.
24.
Tomorrow or Monday we have called for the case diary.
One.
Who take that? 6 के पैसे.
Earlier cases are disposed of, I think, Lordship. Earlier cases are disposed of. I
No, some more matters are pending.
55.
Maybe tomorrow or Monday.
Okay.
So we'll peruse the case diary to dispose of this application also.
25th June. Next date on 25th June. AB.
25th.
1580
25th.
25th. Next date is on 25th June.
Okay, Tuesday then. Tuesday.
1513 report.
1580 For bail hearing, item 2.
Yes.
Application will be filed under section 438 of the series.
Hmm.
This case where FIR is at base minute 14 minutes.
So who is for respondent?
I am appearing on behalf of the respondent.
Acha. Have you filed any objection here?
No.
It's assisted by lord. The petition will send the trial by lord. Someone is issued by lord.
RCP Devi.
Assisted by lord, already my lord.
Yes,
Another assisted person is granted bail from this.
What is that case is pending?
Appearance is
Appearance
appearance is
Appearance is this.
He will appear my lord on the next date, my lord. No, but lordship, there is sufficient materials at the lordship. Sufficient materials at the lordship against him lordship, and he is not cooperating during investigation also lordship. So lordship, at this stage lordship, he only because of the filing of charge sheet
has been completed.
only because of filing charge sheet, he is not entitled.
And where filing of this
164 lordship,
application-
he has implicated this person lordship. I have taken my key lordship, the LCA lordship. Kidnapping is also there, rape is also there. lordship.
No, kidnapping, my lord, not there.
He was confined for 3 days lordship. Thereafter,
And this is the statement of the victim girl, my lord.
We'll go on that,
The
lordship.
statement of the victim girl as well as the other independent witnesses, my lord. Yes, because my LCR has been received, my lord. She, at her voluntary wallet, she arrived in the house of the petitioner, my lord. Thereafter, my lord, the guardians of the petitioner, my lord, has handed over the victim girl to her father, my lord. And subsequently, my lord, she has been married to another person, my lord. Now, my lord, she is a mother, my lord. Filing of the charge sheet, my lord, is not far from granting anticipated bail to the petitioner.
Pardon?
Filing of the charge sheet, my lord, is not far, my lord, for granting anticipated bail, my lord. I have also.
Not very, it can be, but
I have also.
the
I have
nature and gravity of the offense has to be.
order, my lord, from the survival court, my lord, which is at page 38.
No,
my
no,
lord.
nature and gravity of the offense has
Yes,
to
my
be
lord.
taken into
The
account.
petitioner as well as the victim girl, my lord, they are contemporary in age, my lord. And
May I please your lordship, my lord, in this case, I am on interim bail, my lord.
Yeah, we have received the CD, lordship, but I have not found the statement of the petitioner, lordship.
My lord, we went there, my lord, it was not recorded, I told it earlier also, my lord.
Hmm.
Well, we have been there and your lordship has pointed out very rightly on the last occasion that IO is not bound to record the 161, but my going is necessary. They may not record it, my lord. Your last time, your lordship has already said it. So. Because actually, I am the purchaser of land, my lord, and the sale tax and everything has been reflected in my income tax return, my lord, which I have annexed also, my lord. Annex of 5. The property that I have purchased in my return, it is also reflected, my lord. I have paid all the court fee. Your lordship will see, my lord. Page 27 is the return and the statement accounts is that land at Azra 3 Kotha, Dag number 103, Patta number 460. That 15,91,000 I purchased is as part of the sale deed, which I have annexed it also as annex of 4.
Here in this.
Page 22, my lord. This is the sale deed that was executed by following the due process, my lord. And accordingly, my lord, the deed was registered and thereafter while submitting my income tax return, my lord, I have annexed those documents along with the statements of account. I have purchased it bona fide by obtaining the sale permission from the DC. There is no fault on that, my lord. Neither I am an FIR named accused, my lord.
Mr. Lokor, what is the stage of investigation?
Regarding case of investigation, lordship, some evidences have been collected, lordship, some statement of the witnesses are recorded, lordship, most of the accused persons are arrested also, lordship.
No, is there any material against the
Collecting
present
me.
applicant?
That I am trying to find that person. Actually, Aznu or Anju?
Anju. Aznur Ali. Aznur Ali, he was the one of the contractor.
Lordship, may I pray for some time, lordship? Lordship, may kindly fix it on any other day, lordship? I have to call for the IO, lordship, because it's a foreign city and
That's why I told you also in the morning, you said the Indian.
Okay, tomorrow then,
My lord, I'll be out of station. Let it be on 26, my lord, or 24.
So
Monday, Tuesday.
anyone can appear on your behalf
My lord, I have to pay
because
certain thing, my lord. We
But,
have, my lord, to be honest, my lord, I'm submitting, my lord. I have told him I'll be going for an argument at 6:08. I cut short and come to your lordship because he said that court may not give adjournment.
tomorrow.
No, today, my lord. I wanted to seek adjournment. So that's why I pray, my lord, I'll be out of station for tomorrow, my lord. Let it be on 25. 24 Monday probably, my lord. 25 I'll do.
Okay.
Let him take the best of the instruction, my lord.
Okay, on the pair being made by Mr. Lockwood,
Okay,
learned
take whatever
additional
time
BP. Recessal is the matter on Tuesday.
Hmm.
Tuesday.
Tuesday.
So enable him to go to the case daily.
No, what is it? If I complete to deal with
Till the interim order pass earlier shall continue.
Item 4 for orders. নহয় নহয় বহি আছো তো এখানে মই এখানে Item 4 for orders.
Then appears for the appellant on call, recessal is the matter on.
নহয় নহয় মই ভালকে On 17 July. Item number 5, part of letter from the
Please, Your Lordship, I'm praying for a short accommodation in the matter, Your Lordship.
On the pair being made by Miss.
Sir, Your Lordship,
What is your name?
Miss Sidas, Your Lordship,
Learned counsel appearing on behalf of
Mr. P. Mahanta, Your Lordship.
Mr. P. Monto, learned amicus curiae. Recessal is the matter on. When he will be able to, he will be available
Next week, Your Lordship,
next week.
27th.
27.
Item 6.
Much obliged, Your Lordship.
Your Lord. My lord. On that day, my lord, I have taken a plea of Probation Act, my lord, section 4 of the Probation Act, my lord. And lordship wanted to any in case of 307, whether it is applicable or not, my lord. But I have found some judgment of other court, my lord. And my lord, it's considered if it is a first offense, my lord, and there is no, my lord, criminal antecedent, my lord, then,
No, earlier one case was lodged against you by your wife.
my lord, that was a compromise, my lord.
Maybe.
There is no,
So this is of Rajasthan High Court. Whether any
yes,
case
my
of
lord, citing
Supreme Court
some
is there.
decision of the Honorable Supreme Court, my lord. In this judgment cited some decision of the Honorable Supreme
You produce those judgments of Supreme Court.
High Court. So, Lordship supplied one judgment, my lord, this is Virajbhai Gorakhbhai Nayak versus State of Gujarat. Well, I have gone through it, my lord. Regarding, my lord, exception of 304, my lord. Sudden provocation, my lord. My lord, I have seen that, my lord, may not be help in my case, my lord.
Is sudden fight.
Sudden fight, my lord.
How it will be applicable?
Also, here is exception 4 will not applicable also in this, it is mentioned also from the middle.
Because the lady was unarmed and you were armed with one axe.
There is no any fight between between them lordship.
My lord, that's right.
So exception 4 will not come also.
For the man.
Okay, you produce those judgments of Supreme Court that
Lordship.
section 4 of the Probation Act can be extended
Yes,
to the
sir.
applicant to the appellant. Huh? This Rajasthan High Court judgment will not do.
Lordship.
as read for by Mr. Ziuddin, Learned Counsel for the appellant, recessal is the matter on when
The vacation on 18th July.
18 July. Before
Or
that month,
before
that month.
vacation.
Before vacation. it was. I'll try that.
27th,
When is- All right.
item 7.
Yes, my lord, I've got one judgment of the Honorable Supreme Court, AR 1981 SC 379.
Regarding
Regarding that, my lord, that RPF personnel are not to be treated as
police personnel,
police
yes.
Para 58, my lord.
ये citation बताना अभी.
1981, AR 1981 SC 379. AR 1981 SC 379. Party number.
Yes, any other submission?
My lord, yes, now regarding the, already I have stated, my lord, that PW8 is the inquiry officer.
Hmm.
He exhibited, my lord, the statement of conference statement of, my lord, all the accused, my lord, Figu Shah as well as Dinesh Shah and Sushil Agarwal.
Hmm.
Now in the, my lord, LCR, I have flag mark, my lord, the state conference statement.
Hmm.
Sushil Agarwal, one is in English, other two are in Hindi. I'll try to read, my lord,
Hmm.
in the LCR. See flag mark, my lord, I have
Hmm.
in the main LCR file. Yes, that. Figu Shah is exhibit 22.
Whether these copies were translated?
No, these are not, only evidence, but these are, my lord, the exhibits, these are not translated.
Exhibits, but you have relied upon the same.
My lord, evidence part, yes, but the exhibit part they have not translated. But I can, my lord, slowly read, my lord.
Hmm.
भृगु शाह, मेरा नाम भृगु शाह है, पिता डिब्रूगढ़ में रहता हूँ। नलियापुल में अपना स्क्रैप का गोदाम है, जिसे मैं और मेरा लड़का दिनेश शाह दोनों मिलकर चलाते हैं। इस गोदाम में हम लोग बाहरी तथा रेलवे का लोहा फाइल लाते हैं और खरीदते हैं और तथा बेचते हैं। यह सारा सामान विभिन्न फेरीवाला से हम पर खरीदते हैं और तिनसुकिया, मेघालय और गुवाहाटी में बेचते हैं। These are now दिनांक 13/9/2004 तारीख में प्रातः सुबह 8:30 बजे हम दोनों बाप बेटा मिलकर तिनसुकिया के माकुम स्थित सुनील अग्रवाल, जिनका अपना स्क्रैप का गोदाम है, से रेलवे सामान बेचने के बारे में फोन पर बात किए। सुनील अग्रवाल लेने के लिए राजी हुए। उसके बाद मेरा बेटा दिनेश शाह एक ट्रक सेंसर पर तिनसुकिया के लिए ठीक किया। अपने गोदाम से 12 बोरा अनुमानित सामान उस ट्रक में लोड करवाया तथा दिनेश और उसके ड्राइवर महेंद्र राय से काम करने का सलाह देकर तिनसुकिया चला गया। So, this is the statement of Figu Shah, who is the father of the Dinesh Shah, who is sending the scrap. Now, already the ward member, PW5, he stated that his scrap is running, scrap shop is there running in Dibrugarh from last 15 to 25 years. So, now, my lord, next page is the statement of Dinesh Shah. Dinesh Shah is not accused in this case now, as because only fine imposed, but it is relevant, my lord. This is exhibit 21. मेरा नाम दिनेश शाह है, पिता भृगु शाह, नलियापुल डिब्रूगढ़ में रहता हूँ और मेरे पिता का नलियापुल में स्क्रैप गोदाम है, जिसे हम दोनों मिलकर चलाते हैं। यह हम लोग
बहुत सालों से कर रहे हैं। इस गोदाम में हम बाहरी तथा रेलवे का लोहा, पीतल इत्यादि विभिन्न फेरी वाले तथा स्क्रैप डीलर से प्राप्त करते हैं और ट्रक से लाकर वे हम लोग तिनसुकिया, मेघालय और गुवाहाटी में नगरों में उचित लाभ करने से बेचते हैं। दिनांक 13/9/2004 के सुबह करीब 8:30 बजे मैं और मेरा पिता आपस में चाय करके तिनसुकिया में माकुम स्थित सुशील अग्रवाल जिनका हमारी तरह स्क्रैप डीलर है और जिनका अपना गोदाम है माकुम रोड पे, मैंने ऐसे फोन पर हम दोनों ने बात किया। 12 बस्ता रेलवे का सामान के बारे में बात किया जिसे सुशील अग्रवाल लेने के लिए राजी हुए। मैंने एक ट्रक नंबर से भर में ठीक किया तथा गोदाम से उस ट्रक पर बड़ा रेलवे का सामान लोड करवाया। उसके बाद पिताजी मतलब these are the other things, मतलब this is clear that मतलब Frigu sir also stated that with the consultation with son and called Sushil Agarwal at about 8:30. Dinesh sir also stated. Now, other next page is relevant. Others I am not. From the last one, yes. इसी बातचीत के दौरान सुशील अग्रवाल मौका पाकर गोदाम से चुपचाप भाग गए। मतलब सुशील अग्रवाल मतलब fled away from the spot.
Which part you were reading?
The Dinesh statement next page is continuing Malat. की बातचीत के सुशील अग्रवाल मौका पाकर गोदाम से चुपचाप भाग गए तथा और सुशील अग्रवाल के दोनों कर्मचारी गोदाम के अंदर ही थे। आरपीएफ द्वारा गिरफ्तार कर लिए गए तथा आरपीएफ अफसर सो मतलब as Sushil Agarwal fled away, this also comes in the statement of Dinesh sir. In the Gudanwala, Dinesh sir was apprehended and 2 employees of Sushil Agarwal. These 3 persons were arrested, but Sushil Agarwal fled away. Sushil Agarwal was arrested subsequently, and Frigusa, who was stayed in Dibrugarh at that time, and he was arrested subsequently. Now, Exhibit 20. Exhibit 20, next page, no, after that, Exhibit 19, Sushil Agarwal, in English. These all are exhibited by PWA. The inquiry officer. Exhibit 19, Sushil Agarwal. On being asked, I am to state that my name is Sushil Agarwal, so and so, residing at Makum Road, Tinsukia, near so and so school. And the land and house where I am residing with my family stands in the name of my father, Chandra Agarwal, who is residing in Delhi with my brother and doing business there. The fabrication factory is in the name of my wife, Mrs. So and so Agarwal. There is also a scrap godown also attached to the said factory within the same complex. Well, I am looking both the factory and the scrap godown. So land is in the name of his father, the factory is in the name of wife, along with that the scrap godown. He is looking after both, but not in his name. On 13/9/04, while I was available in my so about 8:30 in the morning, I received a telephone from one Frigusa and his son Dinesha of Dibrugarh. They wanted to sell some railway aluminium scrap material and stated me that they are having documents for the same. I agreed to purchase and instructed my worker Shyam Rai and Manoj Tataya. These 2 persons were arrested subsequently. To remain in readiness at about 1400 hours. one truck bearing registration number so and so and so reached at my Godown, and Dinesh Shah, son of Bhigusa, also came by the said truck. On my order, the aforesaid worker unloaded the material immediately from the said truck, which were packed in 12 gunny bags and kept inside the Godown. On demand, Dinesh Shah assured me to give the document were checked and waited taken in my discussing with Dinesh Shah about the rat. RPF officer and staff of Tinsukia suddenly arrived at my Godown and checked the materials and started interrogating Dinesh Shah. Before this, the truck had already left the Godown. During interrogation and checking process, Dinesh Shah failed to produce any document for the said railway aluminium materials, and somehow I would manage to escape from the spot. Later, I came to know about the arrest of my two staff and Dinesh Shah with other details of the case. So, Malad, this is the statement of the Sushil Agarwal. He fled away from the spot. Now, Malad, as per this judgment, this is still in force, Malad. Latest judgment, I have not, Malad, subsequent in Calcutta, I could also relying this judgment in 2018, but I'll some problem in the printer. I could not take out the printout. So, Calcutta, I could also rely this judgment in 2018. So this judgment is in force, still in force. As per this judgment, when any constitutional statement before the inquiry officer is cannot be denied and can be treated as evidence. So, and these statements are exhibited by the inquiry officer PW8. Now, one thing is clear, Malad, that yes, thus the Godown benefit of doubt is given because there is no any land or Godown in the name of Sushil Agarwal. Yes, he also stated land is in the name of his father, factory in the name of wife, but he is running the factory and kept Godown.
So is there any material to support that submission that he was running the business, though the Godown was in the name of his wife and the land was in the name of his father?
Well, from his confidential statement also, Malad.
Hmm.
His statement, he stated that father is.
But this mens rea, can it be inferred from this statement? That knowing that the articles, scrap articles belong to the railway, he has received the same.
Yes, yes, yes.
So,
Regarding that.
What is the relevant section in the RPF Act? RPF or what?
Yes, RPF Malad.
Railway Act.
Railway is Malad 3 possession 3A. Railway Property Unlawful Possession Act. Malad, this is the. Yes, that is the Railway Property Unlawful Possession Act.
Railway Act or Railway Property?
Malad, in the Railway Act itself, your lordship would get the
In
other
Railway Act
acts
itself,
also.
it is there.
Yes, yes.
Yes. Act is Railway Property Unlawful Possession Act 1966.
Compilation.
Compilation. In the compilation itself.
Section?
Section 3. Section 3 of the Railway Property Unlawful Possession Act 1966. Penalty for theft, dishonest misappropriation or unlawful possession of railway property. Whoever commits theft or dishonestly misappropriates or is found or is proof to have been in possession of any railway property reasonably suspected of having been stolen or unlawfully obtained shall, unless he proves that the railway property came into his possession lawfully, be punishable for the first offence with imprisonment for a term which may be extended to 5 years or fine or both in absence of any special and adequate reasons to be mentioned in the judgment of the court, such imprisonment shall not be less than 1 year and such fine shall not be less than 1,000 rupees. And for repeated malad for the second and subsequent offences, the imprisonment for term which may be extended to 5 years. Now already malad one of the witnesses already stated that malad they are malad convicted in the any other case also malad they are convicted same three malad but
Where is the record?
malad yes that I have replied malad from the statement of
Have you mentioned the same in your memo of appeal?
memo of appeal malad that is not mentioned I think.
The record they have produced in the blood, earlier conviction blood, even the IO blood has in his evidence has stated that he has
IO.
collected the certified copy of the earlier conviction.
Acha.
This is there in the
That is
this is the admitted position blood.
and malad
Dishonest misappropriation or unlawful possession of railway property.
unlawful possession yes malad these are not lawfully taken property and Brigusa malad subsequently sent the materials but Sushil Agarwal he is running the business and malad and prior to this incident also they are convicted in the same kind of offense so they are running this business and for this case only malad yes malad he himself stated in his confession statement as per the this honorable Supreme Court judgment malad any statement confession statement before the inquiry officer can be treated as
Admissible.
admissible
Okay.
malad these are the malad
So the problem is that how to deal with appeal against acquittal. The principle has already been laid down by Supreme Court in several cases. So we will examine the issue in the light of those circumstances, those principles. Yes, Mr. Dubey,
May it please the Lord, sir.
you are for Sushil Agarwal.
Yes, my lord. What the other day I indicated to your lordship, my lord, that it's not a dispute that an RPF officer is not a police officer. That. But before taking your lordships, the issue, my lord, your lordship has seen. This is a second conviction, blood, and in second conviction, blood, it's appeal against acquittal. Blood, the punishment is very harsh, blood. And your lordship would see the first punishment. One can get through only by getting a fine. So, blood, in this case, Dinesh Shamlad has been accused, held to be guilty, and he has been penalized with a fine. And his statement is being used also, blood, for convicting accused number 1 and Brigusha.
What would be the second? What would be the punishment in second conviction then?
5 years
Up to 5 years.
Up to 5 years.
Right.
Minimum is not prescribed.
minimum is 2 years
2 years, blood,
not less than 2 years
not less than 2 years. But at times, one sees blood. Clients are also advising the manner blood that if one confesses only, he can get out of it by paying a fine. Blood.
Fine only.
That is what blood of the record blood. That is what has been instructed blood. They were not contesting the earlier case blood, perhaps on that one. Anyway, blood, the fact remains that there was earlier a conviction. My argument would be, Lord, I will be supporting the conclusion of the judgment.
Hmm.
Perhaps there would be some other reasons for that,
Hmm.
in addition to Lord, what the learned trial court has stated.
Hmm.
But my primary plank would be, Lord, the search and seizure has not been conducted in accordance with law. Lord, if that goes, Lord, the entire proceeding goes.
Hmm. Is there any procedure prescribed in the Act
Yes, the act
regarding
says,
search and seizure?
my lord, kindly come to the act for a moment, Lord.
Section?
Section 10, 11, Lord. Your lordship come to 10. If an officer of the, has your lordship got, my lord?
Hmm. Yes.
If an officer of the force has reason to believe that any place is used for the deposit or sale of railway property which has been stolen or unlawfully obtained, he shall make an application to the magistrate having jurisdiction over the area in which that place is situated for issuance of a such warrant. The magistrate to whom an application is made under subsection 1 may, after such inquiries by his warrant, authorize any officer of the force to enter with such assistant as he may require, to search the same in the manner specified in the warrant, to take possession so and so, so and so. But in this case, my lord, no permission of the magistrate has been taken, my lord.
Hmm.
Next, your lordship would see all searches and arrests made under this act shall be carried out in accordance with the provision of the Code of Criminal Procedure. So the
But
provisions
this,
are,
magistrate means railway magistrate.
but the magistrate has been not defined as such, my lord. Perhaps it would be under the CRPC, my lord.
Hmm.
So, my lord, this is one lacuna.
Hmm.
And my lord will kindly see the scheme of things under the act.
Hmm.
Section 5 says offences under act not to be cognizable. And clause 6, section 6 also, my lord. Any superior officer or member of the force may, without any order from a magistrate and without a warrant, arrest any person who has been concerned in an offence punishable under this act or against whom a reasonable suspicion exists of his being so concerned. This section is important, my lord, for my subsequent submission. Disposal of person arrested. Every person arrested for an offence punishable under this act, if the arrest was made by a person other than an officer of the force, be forwarded without delay to the nearest officer of the force. Now, my lord, section 8 and 9 prescribes the procedure. Where any person, 8, is arrested by an officer of the force for an offence punishable under this act or is forwarded to him under section 7, he shall proceed to inquire into the charge against such person. For this purpose, the officer of the force may exercise the same powers and shall be subject to the provisions as the officer in charge of a police station may exercise and is subject to under Code of Criminal Procedure when investigating a cognizable case. Provided that if the officer of the force is of the opinion that there is sufficient evidence or reasonable ground of suspicion against the accused person, he shall either admit him to bail to appear before a magistrate having a jurisdiction in the case or forward him in the custody of such magistrate. B. If it appears to the officer of the force that there is no sufficient evidence or reasonable ground of suspicion against the accused person, he shall release the accused person or on his executing a bond with or without sureties as the officer of the force may direct.
Mr.
To appear.
Dubey,
My lord, kindly
How-
see the last 3 lines. These are very important, my lord.
hmm,
And when so required before the magistrate having jurisdiction, and shall make a full report of all the particulars of the case to his official superior. Well, this last line is very important because he is not carrying out an investigation, he is conducting an inquiry, my lord.
hmm,
With, and when he is found that he has to submit a report to his superior, my lord.
hmm. No, how we are concerned with this section
My lord,
7 and 8?
yes, now my limb of argument would be, my lord,
Hmm,
in the given case, the inquiry officer, though he is not an officer, he is a police officer, my lord, but by his conduct
Hmm.
and going by the constitution bench judgment, which has also been later on clarified in Tufan Singh case,
hmm,
has acted as a police officer, my lord. Because if your lordship would see his deposition, he has arrested him, which power he does not have. He has recorded his statement, and then he has filed this report, which power he does not have. So this is the distinguishing feature, my lord. That since he is acted in the manner, he is acted as a police officer, my lord, which comes within the purview of section 25 and 26 of the Evidence Act. And therefore, their entire case of the prosecution is based on the confessional statement, my lord. That confession goes. And your lordship has seen A2B, my lord. He make a full report of all the particulars of the case to his official superior.
hmm.
So when he is conducting an inquiry, my lord, he has to be within the parameters of this law. But the moment he exceeds his jurisdiction, he becomes a police officer.
Though it is not provided in the act.
Yes, my lord. But that's why I made a statement the day before yesterday, that though he is, but the manner of acting.
Any other point?
Yes, my lord, to lord emphasis on this.
Hmm.
I would take your lordship to the deposition of the IO, my lord.
Hmm.
My lord, there is one more fact, my lord. There was no independent witness, my lord. That your lordship may also record, my lord. So there
Is
is
there
a.
any requirement to that? effect?
Yes, yes. Under the CRPC provision, my lord, you have to have independent witness. And my lord, one witness they were carrying, my lord, Atul Gogo, he was a police officer, my lord. He has said that, my lord, he is the only, my lord, if one can say a neutral, though he being a police officer, my lord, he says that he is not aware whether the owner was there or not.
Hmm. Deposition of the inquiry officer.
Yes, my lord.
That page number
PW number 6.
8.
8.
The inquiry.
8.
Yes.
On 13/9, I was posted at Sub-Inspector Tinsukia post on so-and-so. I was interested to inquire the case. I recorded the statement of so-and-so on 49 statement of so-and-so. On so-and-so source information, Sri Jayanta Das and so-and-so conducted a raid. In their evidence, they don't say, Lord, that they have taken the search warrant from the magistrate, Lord. And there the materials have been indicated, Lord. During the search, one accused, Sushil Kumar, managed to flee from the search. Subsequently, the metals were seized. The date should be 13/9, Your Honor, in presence of available witness.
Hmm.
During the inquiry, I attended the place of recovery and prepared statement. I recorded the statement of the seizure witnesses and other witnesses. I seized one truck so-and-so, which is so-and-so, so-and-so. Further on 110, I arrested Bhrigusa of Dibrugarh on being surrendered at the RPF post. The materials recovered by Makum was sent by Bhrigu from Dibrugarh. Well, perhaps his statement was also recorded under custody. I have collected a certificate regarding the statement. I also collected one landowner so-and-so, so-and-so. Regarding the memo, I issued a memo. I arrested Sushil Kumar Agarwal on 16/9/2001. I had recorded the statement of Sushil Kumar Agarwal wherein the accused confessed his guilt. So, after arresting, he has recorded. So, this is also violation of constitutional provision. Article 3 of, sub-article 3 of Article 20. And also hit by 26 Evidence Act. I'll place those. On so-and-so, I see the original certificate, so-and-so. Madam will kindly see next page. I submitted the prosecution report under 3B against Sushil Kumar Bhrigusa and against others. Your Lordships knows one of the tests is of a police officer that he can arrest and he can also file a charge sheet. The report is equivalent to the charge sheet, my lord. And my lord, there is a procedure also for the armed forces, my lord, that 1956-7 Act, my lord, I'm not getting now, my lord, because under clause 14(1), my lord, I have got one Allahabad judgment, my lord. In that it says that, my lord, even the confessional statement has to be recorded, my lord, in presence of two, my lord, witnesses.
So, in this case, a confession was not recorded in presence of independent
Yes,
witnesses.
madam. But if you have, if your lordship has this judgment, Balkishan Devi Dayal, the apex court judgment of 1980.
Which paragraph you have relied upon?
Lord, this is, Lord, I would like many paragraphs, Lord. If your lordship, the comparison, if your lordship sees, it start in from para 30 onwards, my lord. What is the distinction between, Lord, which the act? From 32 onwards, if your lordship sees, my lord, section 8 is quoted. 33, my lord.
Yes.
Section 14 makes it clear that the provision of the act shall override the other law. This means that if there is anything in the 66 Act which is inconsistent with the code, then on that point the 66 Act will prevail and application of the code pro tanto will be excluded. The most important example is already noticed to be found in Section 5 of the Act, which makes an offence under this Act non-cognizable, notwithstanding anything in the code. This clearly shows that provision of the code cannot propos vigor apply in an inquiry conducted under Section 8 of the 66 Act. By an officer of the force. Further, Section 6 of the 96 Act empowers an officer or a member to arrest without a warrant and without an order of magistrate any person concerned or reasonably suspected of being concerned in an offence under the 66 Act. This again is contrary to the scheme of the content of the Act, which must give way to the 66. The third material aspect in which an inquiry under 66 Act differs from the investigation under the code is to be found under Section 9(3), whereunder persons summoned to appear in the inquiry are expressly mandated to state the truth. In contrast with this, section 160 of the code does not expressly bind persons examined in a police investigation to state the truth. The inquiry under section 8(1) of the Act, in view of section 9(4), shall be deemed to be a judicial proceedings for the purpose of section 191 and 228 of the Penal Code. But a police investigation under section 160 of the code does not partake the character of a judicial proceeding for any purpose, and a witness examined during such investigation cannot be prosecuted under section 193. The fourth important aspect in which the power and duty of an officer of the RPF conducting an inquiry under the Act differs from a police investigation is this. Subsection 3 of section 161 of the code says the police officer may reduce into writing any statement made to him in the course of investigation. Section 162(1), which is to be read in continuation of 161 of the code, prohibits the obtaining of signature of the person on his statement recorded by the investigating officer. But no such provision attaches to statement recorded in the course of an inquiry under 66 Act. Rather, from the obligation to state the truth under pain of prosecution enjoined by section 9, 3 and 4, it follows as a corollary that the officer conducting the inquiry may obtain signature of the person who made the statement. Fifthly, under the provision of subsection 1 of section 162 of the code, oral or recorded statement made to a police officer during investigation may be used by the accused and with the permission of the court by the prosecution to contradict the statement made by the witness in court in the manner provided in 145 Evidence Act, or when the witness's statement is so used in cross-examination. He may be re-examined if any explanation is necessary. The statement of a witness made to a police officer during investigation cannot be used for any other purpose, whatever, except, of course, when it falls section 32 or 27 of the discovery of the materials. The prohibition contained in section 162 extend to all statements, confessional or otherwise, during a police investigation made by any person, whether accused or not, whether reduced to writing or not, subject to the proviso. In contrast with the code in the 1966 Act, there is no provision analog to the proviso to section 162(1) of the code, which restricts or prohibits the use of a statement recorded by an officer in the course of an inquiry under section 8 and 9 of the Act. Sixthly, the primary duty of a member officer of the RPF is to safeguard and protect railway property. Only such powers of arrest and inquiry have been conferred by the city on members of the as are necessary and incidental to the efficient and effective discharge of the basic duty of watch and ward. But if some activity is going on of theft immediately, then perhaps they can, but not searching and seizing somebody else's materials without the power, permission from the magistrate. Unlike a police officer who has a general power under the code to investigate all cognizable cases, the power of an officer to make an inquiry is restricted to the offences under so and so. Last but not the least, under section 190 of the code, a magistrate is empowered to take cognizance of an offence only in 3 ways: upon receiving a complaint, upon a report in writing, upon information received. The report mentioned in subclause B includes the report made by police officer under section 173 after completing investigation. Section 173 in terms make it clear that a duty to making report thereunder on completion of the investigation to the magistrate is that of the officer in charge of the police station. My lord will see that distinction. Such a report shall include the opinion of the police to the result of the investigation. The formation of such opinion is the final step in the investigation, and that final step is to be taken by the police officer in charge of the station and by no other authority. An officer of the RPF making an inquiry under the 66 Act cannot by any stretch of imagination be called an officer in charge of a police station within the meaning of 173 or 190B. The mode of initiating prosecution by submitting a report under section so and so and section so is therefore not available to an officer of the RPF who has completed an inquiry in an offence under the 68. The only mode of initiating prosecution of the person against whom he has successfully completed the inquiry available to an officer is by making a complaint under so and so to the magistrate empowered to try the offence. That an offence of the force conducting an inquiry cannot initiate proceedings in court by a report under so and so. It is also evident from the proviso to subsection 2 of section 8 of the Act. Under proviso A, if such officer is of the opinion that there is sufficient evidence or reasonable ground of suspicion against the accused, he shall either direct him to appear before the magistrate having jurisdiction or forward him in the custody of such magistrate. Under proviso B, if it is appears to the officer that there is no sufficient evidence or reasonable ground for suspicion, he shall release him on bond to appear before the magistrate concerned and shall make a full report of all the particulars of the case to his superior officer. Well, this is the distinction. Proviso A and B put it beyond doubt that where after completing an inquiry, the officer of the forces of the opinion, there is a sufficient evidence of ground association, he must initiate prosecution of the accused by making evidence to the magistrate competent to try this case. So it has to be rooted through in the manner which has been prescribed on that. But in this case, my lord, he has arrested, he has forwarded the complaint. My lord, perhaps, but I'll need almost 20-30 minutes more, my lord. But I have to rely upon 1962 judgment and that Tufan Singh judgment, my lord, clarifying that.
Okay, how much cases are there tomorrow? 7. Any hearing matter? Hearing matter, no? So tomorrow then?
My lord, tomorrow.
So this judgment is completed.
Blood 3-4 paragraphs more, blood.
Acha. Okay. Heard Mr. K.K. Parasar, learned counsel for the appellant, and Mr. Hardube, learned counsel for the respondent number 1, and Ms. D. Barpuzari, learned counsel for the respondent number 2. List the matter tomorrow as parted.
Deeply obsessed.